I agree with you. Because I think the implication of that is, and take everything back into the Trump case and through this, that that as a matter of this Supreme Court's view of the law, we presume that the president is right, and we presume the president has the power to do what he's doing. And there was language, incredibly naive language about that in the Barrett decision. Essentially, the president will, we assume the president will do the right thing on this kind of thing, which is just insane. I would add one other thing before I move to the other case, and that is, there is a non-legal context of this. There is the administrative and the congressional and the budgetary context. And if this bill passes the Senate and the House, and they give ICE a budget that is the equivalent, greater actually than the budget of the United States Marine Corps, ICE is going to be able to violate the law at industrial scale, with industrial speed. And so all of a sudden, you're going to have many, many more violations and many, many more cases that are going to have to percolate their way through this system. And the more clogged up the system gets, the slower the process gets, the more off in the distant future justice gets. Now, another problem was manifest in the case that, again, misleadingly may be referred to in some headlines as a Planned Parenthood case. But what it really is a case about the degree to which citizens can use civil rights laws to protect themselves and get what they deserve from the government. And the court, even as it's taken away, given the president a lot of powers, taken away some others, is in this case, it seems to be stripping away a pretty important right from average citizens. Is that your read on why that's an important case?
I think it's a singularly important case, and I hope it contra your Substack from this morning, that everything disappears, you blink, and we don't have a fulsome airing of what it was. I hope that as the summer goes on, we can really talk about why I think it's an incredibly important case. But you're absolutely right. The gist is you had a statutory entitlement to the physician of your choosing, right? Even if you're on Medicaid. And that's codified in a statute. It's clear what the intent was. And we have South Carolina that wants to defund Planned Parenthood. Planned Parenthood can't give abortions, right? We've got the Hyde Amendment. We've got a million constraints on Planned Parenthood. What it does is all sorts of, STD checks and mammograms and other essential services. But many, many states hate Planned Parenthood. Why? Because Planned Parenthood, in theory, somewhere is still providing abortions. And so the decision is taken that we're going to, right, preclude people from seeking services there. And you're exactly right. There is a statutory entitlement to that. It is not in question. And the court goes ahead and says, yeah, no, that's fine. And so every other state that now wants to defund Planned Parenthood will be able to do so, has a green light to do so. And it is such, again, a willful misreading of, a directive that was supposed to give patients, particularly poor patients, the right to have a physician of their choice. And a very cynical reading, but I think it's of a piece. And you're exactly right that what we get in the dissent is like, this has a long storied history, in civil rights law. This is part of a way of thinking about how helping people effectuate their own rights. And it's gone with the stroke of a pen. And I think, your larger point about both these cases is that it's just not just, as you wrote today, death by 1,000 little cuts, but death by 1,000 like arcane legal abstractions, David. Nobody is like waking up the next day screaming about this case because it seems really, really technical. And, I don't fully understand, what it matters. If you can't get your health care at one place, you'll go somewhere else. But, and again, under the looming shadow of massive healthcare cuts. But I think it goes to, your larger point about all of these things, I remember this time last year we were talking about Chevron deference and trying to get people to like be, 5 alarm fire about what it means to strip agencies of regulatory authority. It's so cunningly done in this way of a million abstract arcane legal principles that it's really hard to get people to see what it is that the court is doing, that they're choking off just fundamental, in this case, statutory entitlements. And it's a bunch of legal jargon and, shruggy emojis. And so I don't know how we get folks to focus on, the thing that you're describing and I'm describing, which is every day, thanks to the John Roberts court, the water's a little dirtier and people are a little less healthy. And, more dark money floods into the system and it's harder to vote. Like every one of those things happens every term. And the response is, I'm sure you get the same mail I do. Well, I don't know what to do about it. Like the court's the court.
Well, and that's the problem. And I do think there, it has stuck in my craw as I have looked back to the first year of the Biden administration, where he said, I'm going to have a blue ribbon commission to look at what to do about the court. And it was complete bullshit. They didn't care about it. He didn't do anything about it. And the reality is this: if this court is allowed to do what it's doing, and you talked about granting cert on, campaign finance, and that goes back, to their greatest hits album with Citizens United and the whole fallacy and pernicious fallacy that money is speech, right? That people can go out and rich people should have greater power in our democracy. But they're going to go down this road as far as they can, and that's not the only case they're going to carve away rights. Just what we've seen this year and what we saw last year, and maybe next it'll be Obergefell and the right to people to marry who they want, or it'll be some other fundamental right. And they punted on a gerrymandering case, and maybe next year they'll get around back to that, and that the only way to stop this is to structurally change the court, because with a 6-person majority, it is the only way. You have to have whatever is 13 justices to correspond to the number of the federal circuits out there, whatever, however you do it, adding states. Something has got to be done, term limits, something has got to be done to change this court, or the court is going to be the engine of the destruction of our democracy. It's not going to be any one person.
Well, I think we're in a foot race now where we have an imperial court that created an imperial presidency that is now being bolstered by an imperial court. So, I think you're exactly right to say they are working in lockstep, and they are working to systematically carve out of any kind of structural checking system, not just Congress, which is supine, but the federal courts, right? I think that's the takeaway. That's where we started, is they are both working together. And remember the language from last year in the immunity decision, the just dripping contempt for, federal investigators, right? These awful, awful people who could indict a ham sandwich. And the dripping contempt we get from this court about, EPA regulators, right? Or people who work on vaccines and diseases. I mean, this has been a slow march from the Roberts, 6 to both dismantle, regulatory power. I mean, we haven't talked about, all the ways in Humphrey's executor is over, all the ways in which independent agencies have been imperiled this term, but to sort of slowly dismantle regulation, slowly dismantle any sort of check on government, and now to go after judges, right? Lower court judges. And I think we just have to see it as part of a progression to say there's going to be 2 winners, and it's either the Supreme Court, not all the Article 3 courts, the Supreme Court, or it's going to be Trump. And I think you and I probably slightly naively believed, because there was some signaling around the Alien Enemies Act when the court was pushing back initially on the shadow docket and saying, hey, if you're going to rendition people to El Salvador, they need a little due process. It looked as though the court wanted to be the decider. And I think that we have to put that to rest. I think the court is no longer super worried about checking Donald Trump. And somebody posted on Blue Sky, and I don't remember who it was, that I can't determine anymore, David, whether it's more depressing that they just don't know how dangerous this is or they don't care. That the 6 justices in the majority are just completely blinkered to what it is that Donald Trump has done and is continuing to do, or if they know and they're fine with it. And I think we're going to now live in the sort of detritus of John Roberts, the great moderate, and Amy Coney Barrett, who had a moment there, when she was supposed to be the big, woke liberal, and Brett Kavanaugh, I guess. And we're going to watch them try to make sense of whether they really, truly want to give, Donald Trump, the loaded gun on the table to do what he wants to do. But it sure feels like when I read Barrett's opinion and I read Kavanaugh's concurrence, I don't see any impulse to shore up checks and balances. I see an impulse to shore up the court itself. That's it. I think that's the only interest that remains for them.